MRCD are people from all these different political parties who come to be part of this union. So to say that MRCD has no members, it's not right, because its members are from each political party that has come together with all these political parties. So we accept that it is a union of different political parties, and the members of MRCD are the members that come from each of these different political parties. Another question is, you say that no one can be a member of FLN only if they are not a member of MRCD. Is that what you wanted to say? Yes, Your Honor, because FLN is the armed group of MRCD. So if you happen to be part of if you happen to be a member of FLN armed group, you are actually also a member of MRCD. If I recall well, Herman, in his defense, he said that he joined FLN without knowing that it was an armed group, a terror group. What do you have to say to that? Thank you, Your Honor. He can join without knowing that it's a terror group, but once he is a member of the terror group and he sees the acts, he sees the work that MRCD FLN have done, it was clearly evident. And him being a spokesperson, he took pride in saying this. He boasted in the acts committed. So him being a member of FLN, maybe in the beginning he joined without knowing that it was an armed terror group, but once he was a member, he knew it was an armed terror group. And we presented this. We presented his statements and his comments. So he knew it was an armed terror group. Perhaps we find that perhaps he joined without knowing that it was a terror group. We will not argue on that. But once he was a member and he knew the acts that they committed, he knew these were terror acts, and he was one of the people who boasted in these acts. He knew what he was doing. Yes, we can carry on. Thank you, Your Honor, for giving me this time to present what we are requesting for. For Sengimana Herman, the prosecution is asking the court to approve that he should be punished for joining a terror armed group according to the law of 1001/ORR. And he should be imprisoned for 10 years for joining a terror armed group. He should also be sentenced for being part of a terror group, as the law 046/2018 states. According to the law against terrorism, he should be punished with 20 years imprisonment. The prosecution also asks that the court considers the explanations given by the prosecution, even what we've just given right now, because the court sees that Herman doesn't deny the crimes, and his crimes show that there was malice and intent, so the sentence should be reduced. The law 68/2018, this is a law of punishment in general. It states that if a crime is composed of different acts, and Article 2 states that different acts are also composed of one crime, the prosecution finds that the crime that Sengimana is being accused of with regards to this law. There are different acts, different crimes, but all part of one main crime based on what is provided of Article 62. Article, can you tell us which crime specifically that composes all these others you've mentioned? What was the main plan? What is the main crime that you're trying to tell us? Thank you, Your Honor. The main intent was terrorism, and in this crime, the two crimes that he's accused are all part of terrorism. So we are asking that we carry on where the prosecution says that based on Law 62, Article 2 of this law of punishments, the court, what's the law? What's the law? 68, Law 68/2018 of the 30th August 2018. I was thinking we were in the 2012 law. Your Honor, we mentioned the 2012 law for the first crime. This is the 2018 law. The 2012 was for joining an armed terror group illegally. But Nsabimana is being accused of these two crimes, and we were asking that these articles of these two laws be the main basis of asking for his punishment. We're carrying on. Why are we not basing on the 2012 law? And then the other one to be punished according to the 2018 law? Thank you, Your Honor. Article 62 provides exactly the way punishments are given. And we found, as the prosecution, we found that these should be the basis of requesting for the punishments we want to request for. Thank you. Thank you. The prosecution asks that, based on this Article 62 of Law 68/2018 of 30th August 2018, the law facing or dealing with punishments, based on this article, the prosecution is asking that Herman Nsabimana be sentenced at the highest sentence, which is the imprisonment of 20 years. Thank you. Thank you, Your Honor. If you may, we can proceed to the next. Thank you, Your Honor. The third defendant is the third accused, and that is RUSESABAGINA Paul. The prosecution accused him of 9 crimes, eight are linked to terrorism, and the next is, which is not linked to terrorism, is creation of an armed terror group. These crimes were committed at different times from 2017 and 2019. According to the crimes that he's accused of, beginning with forming an armed terror group, as it was written in his indictment, and also in the procedure, Rusesabagina Paul, creating an armed terror group, he had this idea, or he implemented this in 2019, and he was working with one of the soldiers in the FDLR, and he was working with Colonel Noel. He was asking him to recruit soldiers from the FDLR, and they formed an armed group based around Ihumure, PDR Ihumure, but they never managed to achieve this because he was captured. The prosecution also finds that Rusesabagina was never discouraged, because in 2017 he had a meeting to negotiate with General Rumbago, Irategeka Rumbago, who was leading the armed group of CDR Ogeyunge. He had soldiers from the FDR, fighters. They agreed to work together and form MRCD, as we demonstrated this in March 2018. They had Sabimana Calixte and his political party of RRM join MRCD. In April 2018, MRCD had RRM join, and RRM joined with their own fighters, as we demonstrated in previous hearings. That is when they formed the illegal armed group FLN, which brought together fighters from different parties, led by General Wilson Irategeka, who was formerly in CNRD Ubgiyunje. He brought fighters, and also Sabimana Calixte Sankara brought fighters, and when they came together, they formed FLN. Paul Rusesabagina and his partners worked together to form a group of terrorists, fighters, who were led by Sankara and Herman. That's how they formed the armed terror group, as the prosecution presented to the court. This was an illegal armed group, and this was a crime punishable by law, punished by Article 200 of Law 68 of 2018. This law is to do with punishments. So this crime that they committed, as provided by the law 01/12 of February of the 2nd May 2015, as punished by the law, this law provided that everyone who forms an armed terror groups or makes contracts to form an armed group using any form of payment, using any form of motivation to attack, they are punished by a sentence of 10 years to 15 years imprisonment. The acts in this crime of forming a terror group, he himself, Paul RUSESABAGINA, committed this crime and he should be punished. The prosecution presented enough evidence, and this was just for recalling or reminding the court. The second part is the part to do with crimes related to terrorism, where Paul RUSESABAGINA is being accused of 8 crimes: being part of a terror group, supporting a terror group, using murder as an act of terrorism, stealing, armed robbery, kidnapping, arson, intentional arson as an act of terrorism, killing as an act of terrorism, battery as an act of terrorism. Your Honor, the prosecution presented that from 2018 and 2019, the fighters of MRCD-FLN took weapons and attacked in some of the sectors in Nyaruguru, in Nyamagabe. These are areas in Rusizi. This was all presented in the indictment. When these acts were being committed, RUSESABAGINA Paul was one of the leaders of MRCD. He was the president of MRCD, and he was one of what was known as the group of presidents or college of presidents of MRCD. As the prosecution explained this, these attacks were terror acts because they attacked civilians, innocent civilians, with the intent of terrorizing people, with also the intent of forcing the hand of the government to sit down and discuss with them. Destruction of infrastructure, causing confusion and chaos. So in this case, in this procedure, the prosecution is stating that all these acts that were committed by the fighters of MRCD in Nyaruguru from 2018 to 2019, it not only affects the people who individually committed these crimes, as it was stated in the procedure of this case, as it is provided in Article 2, Paragraph 3 of the Law 68/2018. This is a law that passed on the 30th August 2018. This law provides that all crimes as provided by the explanations regarding those who individually committed these crimes, this is punishable by the law, but also the person who gave the instructions is punished. And it is here that we find that Paul RUSESABAGINA's involvement is punishable by law. Again, an act that is punishable by law that Paul RUSESABAGINA committed, these are different terror acts as presented, but the act of terror in this case, as provided by the law, we want to clarify. Where in the second article, 4th paragraph B, this law of 046/2018, a law which states what is provided in fighting against terrorism. Any act of terrorism, it is an act that supports, that empowers, that gives instructions, that misguides, that leads, that encourages, incites the participants, that gives weapons, all as mentioned in part A of this paragraph. We find that Paul Rusesabagina should be considered individually as it was defined in part A of paragraph 4, as we explained it yesterday. The lawmaker in Rwanda, in this second article, part A, all the acts of terrorism were defined as every act that is against the law, that could affect the life and the security, batter any given person, any given number of people or a group of people, anything that could affect the infrastructure or the property of the government or people, the environment, or any cultural heritage with the intent of causing terror and fear, using force or people, working or doing any acts that will follow different principles, this all working against the work of the government, giving different services to the people, creating insecurity, creating rebellion in the nation. As we presented it, for any terror act as seen in part A of this paragraph, first of all, there was an act committed which is generally against the law, and that is why in presenting terror acts, we first demonstrate that this was an act that is generally punished by the law, and now it has been committed with the intent to create and cause terror as provided by the law in part A, B, C, as we just described. Anything that will hinder the work of the government, anything, if we say killing or murder committed and we demonstrate it as an illegal element and we prove that this is illegal, it is not allowed by the law, we present that the act is against the law, and we present that the main intent behind the plan that they had was to create terror, and then we define the different acts of terror as defined in the second paragraph, part A and B. But in this paragraph, the lawmaker didn't define largely, but the punishment provided was provided in Article 19 of this law. That's why every time we present an act or acts in the crime of terrorism as provided by Article 4, Part A, B, and then the punishment given, we show that it is punished by Article 19. Therefore, Your Honor, the interventions that we've made and the comments we've made on Paul Rusesabagina we showed that every act we show that it is generally against the law. It is generally punished by the law. If it is theft, it is generally punished by the law. But it is not going to be sentenced as a common rights crime, but because it wasn't done for the purpose of stealing, but the intent was terrorism, as defined in Article 2. Paragraph 4. So we are therefore basing on what was said on Part B, Paul RUSESABAGINA, as one who was leading MRCD FLN, a terror armed group, as one who supported the terror armed group, encouraged them and empowered them in the acts of terrorism committed by the fighters of MRCD FLN as provided by Article 2, Paragraph 4B, Law 046/2018 of the 30th August 2018. He comes as one to be considered individually on his role played as the president of MRCD FLN, as also a member of the College of Presidents, and also as a supporter or sponsor of this terror group. Again, he appears as someone who also committed these crimes individually, as one leading the fighters of MRCD FLN. Even though he didn't actively take part in these attacks, but he's considered as one who played a role by simply being one of the sponsors of these fighters. And the evidence provided, based on what he said before the investigators, what he said before the prosecution, what he said before the court when he appeared for the hearing to do with his detention, and even the different speeches that he said, and also his co-accused, there is enough evidence, even evidence taken from his telephones, evidence taken from his computers. All these are evidences from Belgium. These were provided by the cooperation between the Rwandan investigators and the Belgian investigators. It was evident, and it was seen that he sponsored, and the money given, all of that is in his case file. There is enough evidence of images and sound bites from YouTube and the different announcements that they gave. So, Your Honor, if there are no questions, if you may, after what we have said, we can proceed to the punishments.
Thank you. As regards the sentencing, and we have already, my colleague and I, shown that the 9 charges will be dealt with individually, and a sentence will be requested for each. The prosecution requests that RUSESABAGINA Paul is sentenced for creating an illegal armed group as provided for in the appropriate law, that is the law of 2012 on the Code of Criminal Justice for 15 years, therefore. As regards joining an illegal group, Article 18 of Law 46 of August 2013 on terrorism would request 20 years imprisonment. The charge of supporting a terror group, punishable under Article 69 of 30th August 2018 on terrorism will request a 10-year prison sentence. As regards assassination and killings for purposes of terrorizing the population are provided for under Law 46 of 13th August 2018 on crimes of terrorism, a death sentence, or a life sentence. As regards terrorism, punishable under a law of 2018 on terrorism, 25 years imprisonment. As regards stealing or robbery as purposes of terrorizing the population, and Article 46 of 2018 regarding terrorism, 25 years imprisonment. We request that as regards arson, burning of people, attacking public transport vehicles, that he be punished under Article 46 of 2018 concerning terrorism, 25 years imprisonment. As regards the killing, terrorizing of the population, which is punishable under Law 46 of 13th August 2018 against terrorism, 25 years imprisonment. The charge of attacking and willfully wounding the population as provided for under a law of 2018 against terrorism, 25 years imprisonment. Your Honor, members of the bench will request that the court recognizes that RUSESABAGINA Paul did not recognize all the charges that were brought against him, and yet these are very serious crimes, and we request therefore that he be given the maximum imprisonment provided for by the law. A law of 2018 of a law that concerns the sentencing in general, that are plotting, if there is plotting, and if there is several crimes that come under the same title, but all of them intended to achieve the same objective, the prosecution has found that the various charges were all aimed at the same objective. All of them were intended for the same purpose or the same criminal intent. Therefore, Article 62 of that law will apply, and therefore we request the maximum sentence, which is life imprisonment. And therefore, the court, if the court has no questions to ask about this case, we may proceed. May we proceed? Yes, we may proceed. Mr. President, Your Honor, as we had already said, as regards Nizeyimana Mark, and as has been explained to the court, Nizeyimana Mark has 9 charges brought against him, and we found that whether in his pleading or his other submissions, especially that of April and May as well of this year, the various crimes brought against him were not recognized by him. He recognized only 1 and rejected the remaining 8. And therefore, we should like to explain as regards his denying of the 9 or rejecting of the 8 or out of the 9 charges. As we said, when in court he said that he never knew that he was a member of a terrorist group, that he was never a member of the terror group, and never instructed or encouraged anyone or incited anyone to join such a group. We find, therefore, that this his pleading or defense, rather, on this in this case is unjustified because it is contrary to the facts. Article 46 of 13th August 2018, the law against terrorism, we find that this is the article that applies to terrorism. It says that the law says that anyone who joins or accepts to join or has a role and a function in such a group or does anything that supports or promotes such a terrorist group is guilty of terrorism. Therefore, Your Honor, when we look at what the accused has been convicted of, and we know that these various counts do not necessarily need to be committed at the same time. They may be committed at different times, or just one of them will suffice to be described as a terrorist. Joining such a group, for example, or having some role in that terror group, or doing anything at all that promotes or encourages or supports a terror group. As we have already said during the pleading before the court at various stages, we have already shown that as regards Nizeyimana Mark, the charges brought against him in relation with terrorism that he joined such a group, had a role in such a group, in this case FDLR and then FLN. That the fact that he says that he didn't know that these were terror groups, which is what he brought forward when he was defending himself, we have found that this is unfounded. Because, first of all, if we look at his position in these two groups, he had responsible positions, and therefore since he was a higher up person, had positions of responsibility, he cannot have not known that there were terrorist groups. And he himself had made statements when he was still being investigated, for example, and other times, including when he came before the court, whether previously during his earlier interrogation and appearances, he did himself said that he was a leader, in fact a commander, because he was one of the members of the command structure of those bodies. And in fact he said it, repeated it, including during the trial. Also, when he was questioned in October last year, he admitted himself that he was a commander in the headquarters or command post, but he was also a head of the Zodiac Battalion, which was a reserve battalion or reserve force in the same structure, and he was a commander of that force. And he's been a commandant during many years indeed, a higher up commander, a senior commander, and he himself admitted this, that he was a commander in that organization. He cannot then turn back and say that it wasn't, he didn't know that it was a terrorist organization. Also, this organization that was commanding is a terrorist group, but nobody says, we have never had an organization saying we are a terrorist organization. So he cannot say that the name never appeared anywhere, that it was a terrorist organization. That is not what is the point. The point is the activities or the acts of such an organization, which show that it is indeed a terrorist organization. Your Honor, what we want to show the court is that he had a role, a major, a responsible role, and therefore he knew what were the activities of this organization, which were terrorist activities. And this, it is therefore on the basis of those activities an act committed by this organization that we base ourselves in defining it as a terrorist organization. And he had various responsibilities and high positions, which we have already described. Also, as we said, under Article 18 of the above reference article, or the above reference law, it is provided it provides for active terrorism, but we have various pieces of evidence that prove that he knew that the activities were of a terrorist nature. Further, Your Honor, when we look at what Nizeyimana Mark wrote when he wrote to the court in 2021, earlier, as earlier explained, he wrote with the help of his lawyer. He wrote on page 4 something that shows that he knew that it was a terrorist activity. His lawyer says, defense lawyer says, on page 4 that Nizeyimana never knew it was a terrorist organization, because if he had known, he would have left it just the same way that he left FDLR. This is a lawyer. He's quoting what Nizeyimana Mark himself said. But when we look at this quote, we find that Nizeyimana Mark was denying that he knew it was a terrorist organization. He had joined, and he said that he would have left it just as he left FDLR. This is not a convincing statement, because by referring to his leaving the earlier group FDLR, he means, in other words, that he was in FDLR and then discovered it was a terrorist organization and quit it, so that if he had known that this is the other group that he joined was not a terrorist organization, because otherwise he would have known and then he would have quit it. And he said that he left FDLR because he discovered that it was a terrorist organization. Your Honor, this is contrary to what he said in the court when he was interrogated on this. Second, as we had already shown to the court when we explained the terrorist nature of this organization, FDLR-FOCA, that FDLR-FOCA was listed as a terrorist organization from 2012 on UN, a document called UN Consolidated List of 2012, as said, and therefore at that time Nizeyimana was already in that organization, and which he didn't leave until 2016 to join CNLD. This shows, therefore, that Nizeyimana was a member of FDLR FOCA when he knew that it was a terrorist organization, and therefore his claim that he didn't know it was a terrorist organization is unfounded. Concerning his membership of this terrorist group, Nizeyimana Mark is accused of being a member of this MLCD-FLN, this terrorist organization. His defense is the same as previously described. He still claims that he didn't know it was a terror organization, but we do not agree that this is the case. Nizeyimana Mark, when he came before you, Your Honor, when he was brought to the court, he also described the positions that he held during FLN, which was the fighting branch or the armed branch of MRCD. And in fact, he had already been interrogated about that at various stages by the prosecution, and even when he was during the case of his that led to his temporary or provisional imprisonment. He described the positions that he held, and he showed us that he was the second in command of Sector 2, North Kivu, Rutshuru and Masisi regions. Also, when he was second in command, he learned that CNLD had, which is what he joined when he left FDLR FOCA, that it had joined with other groups to create an LCD, and he said before the court on 24th, he said that we as leaders met every month. No month went by before we met. And their head, their senior leader, Irategeka, explained to them that the two groups, or the several groups had joined, had merged to form this new group that he had joined. Your Honor, I think we were able to show also that Nizeyimana Mark himself explained or testified, in fact, that a number of terror attacks were led by the sector in which he was the second in command, the Sector Nord, the northern sector of this organization. And this is what he said himself, and the prosecution was able to demonstrate that this was indeed the case. As regards his responsibilities, he was a commander, second in command of this specific group, and through that responsibility, he was able to run that his group, the group had joined with another to form a MRCD and FLN as its fighting or armed branch. Clearly, therefore, a person who was so high in the command structure, who had access to such information as he proved himself, he cannot turn around and claim that he didn't know that it was a terrorist organization. He was well informed, but also he played a role, important role, in the works and activities of these terrorist organizations. And it's obvious that it was a terrorist organization because of its act. You cannot say, I didn't know, when in fact you knew what they did, and what they did is what was qualified as a terrorist activities, which led to the organization being labeled a terror group. Therefore, you cannot be a leader and not know what the organization does, and especially if you yourself directly were involved in the command structure of this organization. So the intelligence and the investigations that were carried out were able to, as we were able to demonstrate, show clearly that he knew it was a terrorist organization. In fact, Mr. President, Your Honor, he himself admitted it when he came before the court. When he came before the court in April this year, in April 2011, when 2021, when he said himself that he was responsible on what he called triage, that is the selection and assignment of newly recruited fighters. This is what he said himself, that he selected those who were to attack Rwanda, to join the groups that were attacking Rwanda. He said, no, you see, the higher command asked me to select groups to join this attack. And as a sector leader, I gave the number, but they found that the numbers were too numerous for the available budget. Therefore, they asked me to do a new selection, no more than 100 people, 100 fighters, because the budget only covered 100 people. This is not in contradiction with what we said. So the selection of fighters, or whether you call it triage or by other name, it is obvious that this is an activity for which he himself was responsible. He has said it, admitted it. He said, I had given more than 100 names, and they said, you have to reduce it to no more than 100 of fighters who will then join the attack. And this is what he said. This is what he declared himself. Therefore, it is clear that I think the word he used was, I chose the best elements. J'ai choisi les meilleurs éléments. I selected the best elements and sent them. It's obvious, because what else were they going to come to Rwanda to do? Were they tourists visiting? He never said, no, I thought maybe these people were going home, were under voluntary repatriation. No. He said he knew, and he selected them for the purpose of an attack on the territory of Rwanda. So you cannot say that I selected these people to go and fight and attack, but I didn't know what they were going to do. Or what did you think they were going to do? These terrorist activities, because this is what you selected them for. Your Honor, therefore, we can say that this was a senior leader of an armed group who was responsible to select a group. But the president, can you explain why it couldn't be an attack, maybe to come and do other activities without actually being a terrorist group? No, says the prosecution. We know, we have evidence, we have provided evidence that this group's sole aim in coming to Rwanda was to commit acts of terrorism, nothing else. It couldn't be anything else. And therefore, people were killed, their properties were destroyed or looted and taken away. A lot of people were killed and others were wounded. There was no possibility of any other activity. And in fact, we have the evidence and the outcome of these activities. Therefore, Your Honor, the fact of selecting these fighters is ascertained. In fact, when he was being detained, the dossier that he had submitted in the Gasabo court, in the decision was taken in the month of September, and he again said that he selected fighters to attack Rwanda. He was asked to select these people, and he knew they were coming to commit acts of terrorism, and he said he apologized. He apologized. And in fact, he never said that he may have thought that they were coming for other activities different from what they actually committed, which are acts of terrorism. So he knew, and he admitted knowing and knowingly selecting terrorists. Now, did he prove it himself? But because it's not, he may have said it, but it's up to you to prove that maybe they may have come for other purposes. It's not up to him. It's not enough for him to say that. Yes, Your Honor, said the prosecution. It is up to the prosecution to prove the matter, but when evidence is obvious and has been provided for, and the accused person themselves have admitted that these acts were of this or specific nature, it is already obvious from Orango that these were terrorist activities that had were the aim, the only aim of these attacks. And there were no other aims, none that were declared. Also, Your Honor, above and beyond is in the manner's selection of these terrorist members of this terrorist group, he had already admitted that he had helped fighters cross over to Burundi with their weapons, and that in fact when he was arrested he was still involved in these terrorist activities and really caught red-handed in such activities. Therefore, Nzimana Mark was a member of this group, knowing that it was a terrorist group, and indeed, not only did he know that it was a terrorist group, but he actually himself commanded such a group and ordered or contributed to their the commission of their terrorist acts. So, if you look at his statement of 2020 on in paragraph 13, or in answer to question number 13, he explained a great deal indeed about the terrorist activities that were carried out at various places and at various times. Looking at all the details that he provided under his answer on question 3, he had all the information. He said, this group went to such a place, such a date, commanded by so-and-so, and the fighters were so many. So you cannot have all this information if you did not know what these people were doing. You cannot claim that you organized and commanded all this and you organized all the details of the activities of these attacks, and then because you were the second in command, in charge of operations. In fact, he said, you see, I never really involved myself in politics so much because I was a field commander. I was, down on the ground organizing everything, who was attacking where, when, and in what numbers. Therefore, sir, since he himself gave this information, and he himself said that he had deep and detailed knowledge of the activities of these outfits, and he cannot therefore say that he didn't know they were terrorist acts. One other point, Nzeyimana Mag cannot say that he did not know it was a terrorist organization that he was a member of. In the statement that he made in 2020 on page 3, he refers to another statement he had made earlier. He was answering a question on the various attacks that had been led into Rwanda. He said, Nyaruguru and Nyamagabe activities, I was supporting them because this is what we were aiming at. So he agreed and supported these attacks. Second, he said that the 100 people he had selected came to Rwanda through Nyamasheke. So anybody who knows which route a terror group took to attack what place cannot turn around and he said he didn't know, because he said in Nyaruguru and Nyamagabe these were terrorist attacks. We have proved that they were terrorist attacks. He himself said he supported this morally because in any case they all went in this direction that he wanted. And I myself selected 100 elements to come to Rwanda through Nyamasheke. Therefore, Your Honor, this further proves that he knew that this was a terrorist organization, that he was a leader of this organization, and that he knew what they were doing. And he says this, in any case, was our aim. So that, Your Honor, this proves that he's not right in saying that he didn't know that it was a terrorist organization, because what we said, what we have demonstrated, all point to the fact that as a leader, as a military leader, and very actively involved in the terrorist activities, because he's the one who selected the fighters. He organized, strategized their crossing and the type of the attacks that they were to carry out. Therefore, he cannot say that he didn't know these were terrorist activities because he organized them. And as we have demonstrated, his claim that he didn't know the nature of these organizations cannot be accepted. Yes, I have a question, says President. Oh, somebody has a question. Thank you. Prosecutor, you're saying that the activities carried out by Nizeyimana's group were the ones that demonstrate that it was a terrorist organization. But Nizeyimana still claims that he didn't know these were terror acts. I have a question. Can an armed group carry out terrorist activities without itself being labeled as terrorist organizations? That is, FLN, for example, comes to Rwanda, for instance, and carries out acts of terrorism, but still maintains a name other than terrorist group. Is it possible? Thank you, Your Honor. The accusation as regards Nzeyimana is that FLN was a terrorist organization, being a member or the armed group of MRCD, the armed branch of MRCD. As regards Nzeyimana, he is not being accused of being a member of this terrorist organization, FLN. He is accused of being a member of the terrorist organization, MRCD-FLN. So that is the question. Therefore, you asked, Your Honor, that an organization can commit acts of genocide without being called or labeled a genocide organization or a terrorist organization, sorry. Therefore, as the law provides, that is impossible. Let me make a general and a statement of the general nature. First, we have demonstrated to the court with evidence that there are two explanations to be given as regards a terrorist organization. First, such an organization must have a specific structure. Second, it may have been founded with the purpose of committing such acts of terrorism. And therefore, Your Honor, you cannot have an organization, an armed group, or any other type of organization that commits terrorist activities having the structure described by law without being called a terrorist organization. It is automatically ranked under terrorist organizations. Therefore, as regards FLN specifically, we have already said that it cannot be separated from MRCD. It is not two independent bodies. No. And my colleagues have already mentioned that. You have MRCD, FLN is really a unit, the same structure, which has two aspects, let's say. Because when MRCD created FLN as an armed branch of itself, therefore, it shows that it was never separated. And also they said, using the term, by all means, they selected specifically terror as a means of achieving their end. That was specifically selected. Therefore, all the evidence that we provided to the court, nothing shows or nothing can lead us to conclude that FLN may have carried out these terrorist activities and then turn around claim that it wasn't a terrorist organization, because it was created for that purpose. And we discussed that yesterday. We provided evidence. We showed that Simon Lakalit had himself explained what they aimed at, what means and tools they will use, what activities they will actually carry out on the ground. Therefore, Your Honor, as we had previously had cause to prove, there are terrorist organizations that are not armed groups, but armed groups that carry out terrorist activities are terrorist organizations. Because, in fact, we must recall that these were illegal armed groups that carried out terrorist activities, and therefore they are automatically labeled or ranked as a terrorist organization. But FLN is not FLN alone. It's MRCD that is the parent organization that created it as its own armed group. Therefore, it is MRCD, FLN together that is a terror organization. This is how they were constituted. This is how they were created, and therefore they fall under the legal definition of a terrorist organization. We were able to approve this, Your Honor. When we discuss the structure of this organization, its activities are either already executed or planned. So, Your Honor, it is not possible for an organization that carries out acts of terrorism to still be called something else or anything else that is not a terrorist organization. It is automatically and logically demonstrated to be a terrorist organization. Have we answered your question? Yes, we have. This is a question that we have been wondering about, but we accept the definition that you gave. In other words, what is the definition, or what are the elements that constitute a terrorist organization? Is it because you plan to do such act, or you actually execute them? I think we answered this, so please can you repeat what makes a terrorist organization? Because even if MRCD FLN was an armed group, all of it an armed group, and commits act of terrorism, does it become a terrorist organization, or is it simply an illegal armed group? This is the discussion that we've been discussing among ourselves.
We need further explanations to understand, or even in the future for the other defendants to present their defense. Thank you, Your Honor. The explanations we gave, and it's still the position of the prosecution, it is based on Article 2, Part 11 of Law 046/2018 of the 30th August 2018, the law against terrorism. This is where it is fully explained on the definition of a terror group. It's a group of people who follow a plan, who have the objective of executing terror acts. Well, if we would refer to other definitions in other languages, in English it is said
Group is a structured group, persons acting in concert and with intent to commit terrorist act. Un groupe terroriste, c'est une association structurée de personnes agissant de façon concertée en vue de commettre des actions dans des actes terroristes. Monsieur le Président,
Your Honor, we find that the prosecution gave evidence that actually go beyond what the law provides. We went beyond. Why do we say this? The law provides that it's a group of people, persons who are structured, who have a certain structure, who have a plan to execute terror acts. What is evident here is that the same group, before they commit any acts, the simple fact that they have the plan and the intention to commit terror acts, they have instantly become a terror group. The reason why we have found that the prosecutor actually gave more evidence, more than provided or requested by the law, is that the prosecution actually presented that this group had an intent of committing terror acts, and they went beyond the intent and actually committed those terror acts. We said this, Your Honor, if FLN had committed these acts as FLN, as people who woke up one morning, formed this armed group, and we want to bring the hypothesis that MRCD is not here. It wouldn't have changed the fact that FLN qualifies to be a terror group, because it's a structured group of individuals, of people, as the evidence that we presented. When we look at the different testimonies, the statements that they gave, it was a structured group. They had a senior leader, they had General Irategeka, they showed the different sectors they were in, the battalions. They presented how this terror group had a structure and how it functioned. It was known. Even people who were members of that terror group presented the structure. Another thing is, if this group, if they have the plan to commit terror acts, so they didn't just have a plan, they executed the plan they had. So we're saying, if MRCD never existed, and it was just there as a group on its own, independent, without anything else, today we would still be accusing members who played a role in the acts of terrorism, being members of a terror group, because that in itself was enough for the terror group, this terror group called FLN. It was a terror group. Or else, if there was this terror group and they don't have this name FLN, but there was a group of people who organized themselves as these were organized, and they committed the acts as these committed in Rwanda, we would still have it as a terror group that has no name, but which exists and has performed these terror acts. So, Your Honor, these are different hypotheses, but it's still real. We are here before the court today. Before we go to the real hypothesis, as you say, let's take this group, FLN, if it was just FLN, because you're telling us that you're not just accusing FLN as an armed group, a terror group, you're saying it's MRCD FLN. Let's just take that hypothesis. If it was a group of people, armed group, illegal, committing terror acts, does it immediately become Does it become an illegal group, an armed group? Are they accused of the two crimes, being part of an illegal group and then part of being an armed group? How does that work out? We want to hear how you explain it, so that if the defense has anything to say on this, they will still have what to say. Let's take the second hypothesis, an illegal armed group committing terror acts. Does it make them a terrorist group? Your Honor, we find that these crimes, if we maintain this hypothesis that we had, the two crimes, they would still be accused of the two crimes because, as we explained, these different crimes, the accused being members of an armed group, illegal armed group, being part of a terror group, these crimes, they're acts different but on the same purpose, which is the one crime they have in common. We had said it earlier. All terrorism committed is not done in armed groups. Being part of an armed group is not an element of what makes a group a terror group. But as people intend to commit terrorism, the way they choose to commit this terrorism, some would choose to use individuals. They could set up bombs, they kill people, destroy infrastructure, destroy roads, destroy bridges, different acts, destroy cultural heritage sites. These are some of the ways they might use, but these groups might choose to use fighters with military training. And this was also one of the ways used by FLN in the hypothesis we were giving. So it doesn't make the act committed, because generally that is also against the law, but it doesn't remove the fact that this armed group committed terror acts. So they will be sentenced for the terror acts because they have chosen to use fighters or armed fighters to commit these acts of terrorism. Whatever they have chosen to use, the act that they are committing is against the law and it's a terror act and it deserves to be punished. So we are saying that they should be punished for the two. So now let's go to the second hypothesis, which you call the real hypothesis of what we have now. So we have started with these other hypotheses so that we reach what we have now and what we are presenting before the court. If there was, we don't have FLN as an independent group, but we have FLN as a group.
Mashyaka yitwa MRCD.
FLN group founded by MRCD. We came back to this, Your Honor, when we were looking at the statements made by Nsabimana Calixte. He said we made FLN to be able to negotiate with the Rwandan government, but here we have FLN, if we can use this speech, we have FLN which didn't wake up one morning and people just make a group and they form something called FLN, but it came from another group which is MRCD, which lived or existed before FLN. So this comes from the question that was asked. FLN cannot be an armed group that commits terror acts, but it doesn't become a terrorist group. But we said it has to be structured. It has to commit terror acts. And this is what we have presented. This is what the law provides in defining terrorism. Today this is what we have kept coming back to. MRCD, FLN is one. MRCD existed and formed an armed group. We showed it in the announcements they made, in what they said. The leaders of MRCD founded FLN, and they gave them different tasks. And Your Honor, we find that this doesn't make FLN members exempt from sentencing. It doesn't remove sentencing for the acts. It doesn't also remove the sentence of being part of an armed group and a terror group, because we looked at this and we looked at the different elements that were members of MRCD FLN. So we find that people need to face justice for these two crimes. The first being part of a legal group illegally, and there were evidences to prove this. And the second is that they were part of a terror group. In other words, we are presenting to the court that these two crimes, the crime of being part of an armed group that is illegal and also be part of a terror group, these are not crimes that are not incompatible. They are compatible. One individual can be accused of these two crimes, and then when it comes to punishment, we follow the law according to the punishments that should be given for these crimes. So one crime isn't separated from the other. If they are compatible, isn't one special and the other? Can we say that terrorism, being part of a terrorist group, is a special case? And then we ask ourselves, which one should be treated as a special case? Can we say that terrorism is a special crime on its own, compared to being part of an armed group? If we understand the question of the court, Your Honor, for it to be special, we would say it is special based on its components and the law punishing it. But we're presenting to the court that based on what we have, the evidences we have, it was a group of fighters, a legal group of fighters, and this is what we kept coming back to. Being part of a group of illegal fighters, it in itself is a crime, and it is punishable by law. But if this armed group, the terror acts that they commit, we find that what they do does not remove the crimes they had previously committed. Based on the person who is being accused, how they committed these crimes, we find that the position of the prosecution is still the same. Both crimes, the people who are being accused of these crimes, they should face justice based on each of these crimes, and that would be the ideal. Yes, we have come back to the laws a lot, but so now you're telling us that this is the way that was used? The armed group, they used these acts. I don't know if this could be understood as you're saying, But as we were saying yesterday, as we were presenting it yesterday, when MRCD was founding this group, armed group, we presented evidence of their declarations, what they said, what they did, the attacks committed on Rwandan soil. We presented that this group was founded for the purpose, the sole purpose of committing terror acts. And they said that there were no negotiations between them and the government of Rwanda, so they were going to use all other ways possible. That statement, it is an inciting statement to prove and to show that what they did was known. And the requirements needed for a group to be called a terror group, we find that this went beyond planning, but into execution. They committed terror acts. And this shows us that from the beginning, when they founded this group, from the beginning, it was to create a terror group. So to say that this was the way used, to explain this better, we have said that all terrorism doesn't necessarily have to go through a terror group, because there are some that can create terror, cause terror, but not necessarily be members of a group. There are some who commit terrorism as individuals, not connected to any other group, not affiliated to any other group. So to say that this was the way used, to us, it would come off as undermining the work done by this armed group. But what we are saying is, this terror group of MRCD FLN chose to work and to do terror acts coming from this group of fighters that was illegally founded, and that's what we wanted to highlight. So the issue we're coming back to, though we are running out of time, is that if there are different ways to commit terror acts. It could be as a group, it could be as individuals. Would we say that this was done in the way of creating a group? Why can't there be just this crime and then these other infractions not be considered? Thank you, Your Honor. And yes, these are part of what you have just explained to us. Or should we come back to it because time has passed? Can we take a break? The 15 minutes. The court is adjourned.
Urukiko
The court is in session. The court is in session. Can we carry on? Thank you, Your Honor. If we go back to the question we had been asked before we took our short break, we were being asked if both crimes, if one can be a minor crime and the other one be a major crime, or if both crimes should be considered the same. We find that even if this was the case, a person who has committed both crimes to be part of an illegal armed group and to be part of a terror group, they should be tried for both. And if we look, we find that the law provides that for both crimes, in the punishment allocated to them, the lawmakers paid attention to both interests for both crimes. And we find that this is emphasized by what we had said earlier, that these are two crimes. If someone has committed both crimes, they should be tried and judged on both crimes. Then we would come to the punishment of both crimes, as we had stated earlier. We don't know if we can proceed. Yes, we'll proceed. We'll write what you have told us. As we had said it in the first part, in Nizeyimana Mark's defense, his defense on being part of a terror group, and the second was on his relationships with government staff, foreign government staff. Nizeyimana Mark, when he was defending himself in his written submissions to the court, and also, or even before we look at the procedure, let's look at the submissions. In the submissions, he said that he agrees with the prosecution on how things went. He made reference to his written statements of the investigation of 15th July 2021. And in particular, he said that he agrees with the prosecution on how this took place, but on the response of point 12 of that written document, he says that he disagrees with the prosecution on that relationship that he had with foreign government staff, that there was a plan to attack Rwanda, but that he had gone to get weapons for protection. After this written statement that was uploaded in the system in February in 2021, and in April 2021, Nizeyimana Mark and his defense counsel changed their statements, because the first time they said he had gone to Burundi to acquire weapons for protection while in Congo, but in the second, he said he went to Burundi not as an FLN representative, but as a representative of ECL, and they had gone to get bullets. And in other instances, he said they went to Burundi to flee from the fighting that was taking place. And he also said he had gone to look for where soldiers could find rest. All of this is in the written submissions, and others are in the written statements of the hearing of the 29th April 2021. Your Honor, we find that in his defense, Nizeyimana Mark on this crime and on what he said in the concluding statements and submissions, when he says how it went before the investigators on the plan and the plan that they had throughout, he says that he had gone to look for bullets. In other instances, he said he had gone to look for guns. It was not for attacking Rwanda, but for ensuring their security, that they had gone to find a place for the soldiers to rest. All these different statements are contradicting. The prosecution finds that there is no basis, none of them is truthful, based also on the evidence that we've provided.
Monsieur le Président, iyo turebye
Your Honor, this charge of intelligence with foreign elements or foreign officers, we find that Nizeyimana rejected this accusation, and he kept changing his discourse. But in fact, he was sort of explicating all that, finding new ways of presenting these activities in order to avoid the reality, which was that he was looking for support for his combatants. During his statement after his questioning in 2020, when answering question 12, he said, "I agree with what is stated in question 12, but there are a number of things that I do not agree with regarding especially the objective or the intent." So on 18th February 2020, he left Yanda, went to Cibitoke in Burundi, and he was with the 114 battalion, along with a man called Niyonzima, who was in G2, that is, he was in the command center of the Burundi army, and he brought him ammunition, including 3 boxes of bullets that he bought, and the rest were as gifts or donations from that member of the Burundi army. Also under question 12, he also said that he agrees with the facts that are described by the prosecution. And he repeated that many times, reiterated that he agrees. Even a month later, more or less a month later, he repeated the same to the prosecution, and he repeated what now he stated under question 12. Also on question 20 and 21, when he was answering them, where he explained how he went to Burundi, how the 112 battalion received and hosted him, and in fact, one Niyonzima, an adjutant, gave him bullets. Some of the boxes paid for, others are as a gift, box of bullets. He said, therefore, that he agrees with what is stated by the prosecution and on those that document which was which he signed and approved. He said that he agrees with the description of the facts. He also adds that when they went to, that they actually went to Burundi, and then they were at this military barracks, or rather the high command, and one adjutant gave him the bullets, in fact under instructions from one Lieutenant General Fabien, who organized all that. On page 5 of the same document, where he went on explaining about this trip or the mission to Burundi, there was a contradiction. He said, well, as far as I'm concerned, personally, I knew nobody in Burundi, none of these people, and in fact, in no other country did I know anybody at all. But this is a very serious contradiction, Your Honor, because already from the time that he was under arrest or even under investigation, he said that he agrees with everything that is in the document which contained that Article 12 that I described concerning how they were helped to get into Burundi. A car came to get them, and they went to the barracks of that battalion. They spent some days there, and then he also asked somebody to take him to Mabayi, to another place, another military post, and he said, no, the Burundian army didn't allow me, so I remained in that battalion barracks. Okay, so it's obvious that he described all this, and then now he turns around and says that he knew nobody in Burundi or any other foreign country, that he has never spoken to any foreigner. Well, I don't think this can be accepted as truth, Your Honor, because when he said that he went to Mabayi, because there was he wanted to go to Mabayi, but they didn't let him, and so on. So he's contradicting himself, because first of all he said he went to Burundi, was received and did all these things, and they were given this and that, and negotiated this, but then he turned around later and said, no, I knew nobody in Burundi. That cannot be a fact. In fact, he and his lawyer previously confirmed that they were helped and they were given those bullets and other ammunition, or those munitions by Adjutant Niyonzima. But after saying that, they cannot come later and say they didn't know anybody, because this is a contradiction. I think the prosecution has already demonstrated that there was cooperation or collusion with these people from foreign countries or entities from foreign countries. And then, as his lawyer said, he said that he cannot accept this charge because these meetings with foreign countries have not been demonstrated to have led to any fighting or any violence or any attack. Well, this is just another contradiction. He's saying now that I cannot be punished for this, and I cannot accept this charge because the meetings that you describe did not lead to any attacks acts of violence or such like. This is not logical, and the lawyer must have seems to have confirmed this, because they wrote it down together in their statement. But it is a falsehood. Article 193 of Article 63 of 30th August 2018, the law on sentencing. It is clear that intelligence or collaboration with foreign countries for the purpose of obtaining support for terrorist activities is a crime. When such contacts, collaboration, or requests for support are intended to support act of genocide, to support or promote. Your Honor, this law is clear in its intention. When this crime was described as or ranked as an act punishable by law, the intent is that such cooperation with the foreign entities in itself, if it's done for the purpose of seeking or obtaining or securing or certainly seeking support for a terrorist activity, is punishable, because there were relations with foreign government agents, and he just said that he did, yes, contact these people, he obtained these things, yes, but it was not for terrorist activities, and it led to no violence. No. It is just enough to be in contact with the government, its workers, and the representatives, or for the purpose of obtaining support for terrorist activities against Rwanda. Therefore, sir, we can conclude that the way this appears obvious, it is punishable by law, and it is clear that how Nizeyimana described the matter is not the point. The point is the intent. What is the intention he had? What the intention he had when he went to seek that help? An intention to wage or support a war. And that was the fact. So any person who supports or intends to support an armed attack or other violent action against Rwanda is guilty of this charge. So, in this particular case, it is not the results of the intention that is judged, it is the intention itself. Was there an intention to support, promote, or otherwise abet a terrorist activity? And as the prosecution had said previously, we were able to show that even Nizeyimana himself had accepted this in the document that he signed, and that the intention was no other than attack Rwanda. And this is what the law provides for. Your Honor, the evidence that we have provided to this end is that these foreign countries, either 114 battalion in Burundi that put him up for a whole week, whether it is this adjutant Niyonzima who brought him bullets or munition, at any rate, that the intention was to use these to carry out terrorist activity. Nizeyimana Mark, as has been earlier described, was the second in command of the FLN sector that actually provided the fighters that attacked Rwanda at various periods in various provinces and districts. Your Honor, we were able, when discussing the 2018 statement from MRCD proclaiming to have created FLN as the armed group for the purpose of attacking Rwanda. The attacking Rwanda meaning, being intended as an effort to topple the government, and Nizeyimana Marx was part of that command because he was the second in command of that sector, and therefore cannot be said to have ignored or not known the raison d'être of FLN, the intended purpose of its creation, and what it actually carried out. He went to Burundi to obtain munition from a member of the foreign army, and therefore he cannot say that he didn't know what those bullets that were given him were going to be used for. And we have already demonstrated this because even when he was arrested, he was already in possession of weapons and munition and other military gear, and he was on his way to Burundi once again. So Nizeyimana has already demonstrated that he went to Burundi twice, 2 different times, including the time that we explained where he was housed in Battalion 114 and then obtained the bullets. A second time was when he again moved to Burundi with a number of fighters, who the intention being to attack or prepare and attack from Burundi. And then another time when he had crossed with 115 people, crossover into Burundi with the gear that he had with him at the time and various pieces of equipment. He also said that they were going to go there to prepare an attack alongside General Jeva, an attack that would be, in fact, a means of preparing a further attack as described in the evidence. And this is what happened up to the time that he was arrested and detained. The conclusion, therefore, sir, is that what Nsanzimana did in cooperation with this foreign power was not an isolated incident. It was just part of the whole process of preparing terrorist activities, which they eventually did carry out on the territory of Rwanda. The first time when he said that he was going to meet his fighters that were in the Mabai commune. When he came to court, before the court, then he said something else. He said, oh no, I was just going there to prepare a place for my fighters to go and rest after their attacks or their combats. There is a contradiction. You pay $300 to buy 3 boxes of bullets, and you are gifted 12 boxes more, and you say, "I know, we're just looking for a place of rest in Burundi." This is contradiction. You are going to run away from war to go and fight, or rather and hide in Burundi because, you know, the Mai Mai and other local groups in Burundi are harassing you, want to go and rest. But if you're going to rest, you cannot be going to buy weapons. So do you need when you go to Burundi to rest there, do you need those bullets in Burundi or these other ammunitions? Therefore, sir, this is just a manner or way or an attempt to evade responsibility, to avoid recognizing responsibility. So, and also, this is not something that was isolated. We have to see this in a wider context within the overall activities of the FLN and their attacks at various periods and in various parts of Rwanda. A number of people were arrested or had been arrested, and they were also part of this particular armed group, and they explained or testified explaining what they were doing in Burundi. Mark Nizeyimana himself has said, when referring to this, Lieutenant Colonel Fabian was their representative in Burundi and the coordinator of all the activities. And this Nyunzima, the adjutant Nyunzima, was one of those who were coordinated by Fabian. Hakizimana Theogene also testified, saying that General Jeva had sent him to Burundi on mission to go and see another general called the Moran, who was to be given a laptop. His real name is Sinayobye Barnaba, or Bernardin. And Mark Nizeyimana went to Burundi. He worked with the officials in Burundi. He was given bullets, but they also put him up for a while. He enjoyed their hospitality, and he worked with them in various manners. And in any case, he already had representatives on the ground in Burundi. And all this was preparation for attacks against Rwanda, which demonstrates, therefore, that his collaboration with foreign representatives or members of foreign authorities was intended for nothing other than supporting finding provisions for their terrorist activities. So he had accepted these charges, although later on he tried to, relabel or requalify them, but he did accept them. And it is clear that his activities were related to supporting his terrorists or their terrorist activities against Rwanda committed on Rwandan territory. As we said, for There are 9 charges, but he only accepted 1, and the others he sort of evaded or reformulated or trying to somehow evade the reality. But we have already demonstrated, Your Honor, that we cannot accept his defense because it is obvious, as we've just said, that these activities were of a terrorist intent. He also had the same defense, or there was it was the same defense on these 8 counts, all of them overall. So we will not distinguish them. First of all, killing as a means of terrorizing the people, kidnapping for terrorism, armed attacks for terrorism, arson intended for terrorism, kidnapping and abduction to terrorize the people, and kill them, wound them, maim them, intentionally harm them as a means of terrorizing them. As the document they submitted to the court, he and his lawyer, especially in April of this year, 2021, Mark and his lawyer said that he cannot be held responsible for these activities other than the one that he accepted for these charges, because he was not personally and intentionally responsible for them. So, Your Honor, I think this defense cannot be accepted and cannot be taken into account because he was one of the leaders of MRCD-FLN. He was a colonel at a high rank, and we have already demonstrated that FLN was an armed branch of the party, and that in addition to being of that rank, he was also a leader. He was the second in command of Sector 2, or the second sector, and this is the sector where most of the fighters that attacked Rwanda came from. And further, it's not just that he had this position, but he himself, on a personal basis, personally and directly, selected the fighters, either those to be sent to Burundi or those to be sent to Rwanda and attack. And also, we demonstrated that he actually went out to look for military and other support. On the basis of the article that we read earlier of the law on terrorism, which we will not read again, Your Honor, we would like to conclude that Mark was responsible for these activities, including the fact, by virtue of the fact that he was a military leader of this armed group. Second, that he is the one who selected fighters, which means, of course, that he was aware, as was the command center, command level, that he was aware of what went on and for what purpose. That is terrorist activities that were being planned, and this is why, it's for this purpose that he selected the fighters, either to come to go and attack, or to go to Burundi and obtain preparation and other support. There is also some jurisprudence that was evoked as to a high court case On genocide again, this is a law of 13th January 2012, where that is the case of Major Bizimana Andre, and it had to do with the responsibility of a commanding officer for the activities of those under his direct command. Therefore, he cannot say that other people did what was done and he wasn't there, because as their direct commanding officer, he was responsible. And also, there is no substance in his defense when denying responsibility for these acts. Further, as we will show that Bizimana case and Nizeimana case are not identical, even perfectly similar, still there are aspects in Bizimana's trial that support the prosecution's case to the effect that the accused should be held responsible for these crimes. The Supreme Court said that Major Bizimana Andre knew that the gendarme committed genocide in Nyamirambo and did not take any measures to punish them or to report them to authorities that would trial them and punish them. Therefore, he is responsible for those acts, and he is therefore guilty of genocide, as the in fact the army tribunal, military tribunal, provided for. We will not read the case, sir. We just read refer to one paragraph, but there is nothing that the Supreme Court approved or in its decision that will not apply to this case that we have here. In this particular case, there need not be personal, individual, direct participation. It's not necessary. If he was a commanding officer, these were people who committed these atrocities. He did not punish them. He did not report them to higher commands, to higher up, so that the high command can punish him or take measures that are required. Therefore, he is responsible because he was the leader of that unit of the army. Therefore, although a number of different, a number of items in the Bizimana or the Supreme Court case are different, and in fact, even the charges are not exactly the same, but there are similarities. However, similarity or no, there are fundamental differences, because in the Bizimana case, it was a matter of superior responsibilities. That is the responsibility of a commanding officer for the act of his unit, the unit he led. So this is different. He was condemned for being a leader. But in the case we have here today, sir, especially the paragraph A and B of that article. In this particular case, the accused was the leader, and he was the one who led, not only led, but prepared the activities and prepared also the attacks. So here there are two items that may be similar perhaps, but overall the Supreme Court case that I've just cited is not the same that the case we have here, and therefore he cannot be tried under the same article that the Supreme Court rendered its judgment. So he will have to answer these answer for these charges himself. You know, Maître, it's time now. I think we should have a break and come back as usual after 1 hour, and then you resume where you have now stopped. The court now goes into recess.
urukiko.
The court is in session.
Urukiko rusubukuye iburanisha, twakomeza n'ubushinjacyaha.
The court is in session. We can carry on with the prosecution where we left off. Thank you, Your Honor. We had just presented to the court what the prosecution says about Nzeimana Mark's defense. We want to proceed to his punishment, then move on to Bizimana. Thank you. Thank you, Your Honor and honorable judges. As my colleague has said it, after demonstrating the interventions of the prosecution, we have now reached the punishments. The court should sentence Nzeimana Mark for joining an illegal arms group according to Article 485, Paragraph 2 of the 2012 OL law of the 2nd of May 2012. And for this sentence, we are requesting for 10 years imprisonment, and Mark should be punished for being a member of a terror group, a crime punished by the law 18 of law 46/2018 of the 13th August 2018. And this is the law against terrorism. And for this crime, he should be sentenced to 20 years imprisonment. The court should also sentence Nzeimana Mark for holding relationships with foreign state staff, and this is a crime that is punishable by law 193 of law 68/2018 of the 30th August 2018, providing punishment for crimes, and for that he will be punished with 25 years imprisonment. Again, Nzeimana Mark should be sentenced for killing as an act of terror, and this is a crime punished by the 2nd article, and also Article 37 of law 46/2018. This is a law against terrorism, and he should be imprisoned. He should receive life imprisonment. Nzeimana Mark should also be sentenced for kidnapping as an act of terrorism, a crime punished by Article 2 and Article 19 of Law 46/2018 against, and he should be punished with a 20-year imprisonment. He should also be sentenced for stealing, armed robbery as an act of terrorism, a crime that is punished by Article 2 and Article 19 of Law 46/2018, the law against terrorism, and he should be punished with 20 years imprisonment. Nizeyimana Mark also should be sentenced for the crime of arson with intent for destroying people's property, and this should be punished again by law Article 19 of the same law 46/2018, and for that he should receive punishment of 20 years imprisonment. Also be sentenced for killing people as an act of terrorism, and for that he should be punished by Article 2 and 19 of the law 46/2018 of the law against terrorism, and for that he should receive 20 years imprisonment. Nizeyimana Mark should also be sentenced for battery as an act of terrorism, and as provided by the law Article 2 and 19 of the law 46/2018, the law against terrorism, and he should receive 20 years imprisonment. Based on the explanations given by the prosecution, the court should judge that Nizeyimana Mark only pleaded guilty to one crime of all the crimes. So this shows that he didn't plead guilty for all the crimes against him. And yet there are other crimes that he committed with intent. And based on Article 61, paragraph 3A and B of law 68/2018, as provided by laws and punishments, the first act with many crimes, or the first crime with many acts, but with one main intent, the prosecution finds that the crimes committed by Nizeyimana Mark are all grouped together in one crime, with the crime as based on Article 62, paragraph 2 of the same law that we've just mentioned. We're asking that he receives maximum sentence for the crime above all the other crimes, and he should be imprisoned for life imprisonment. Thank you, Your Honor. After the crimes mentioned for Nizeyimana and the punishment, I would request that we proceed to Bizimana Kassien. Thank you, Your Honor. The prosecution is proceeding to Bizimana Kassien, as it was evident in his indictment, and his indictment was explained before the court. He's accused of 6 crimes. We will not go back to the labeling of the crimes, but we'll come back to the defense on all those crimes. His defense, whether in court or in written statements, in this year, May, Bizimana Kassien defended himself, pleaded guilty to all the crimes, but had his ways of explanations or his reasons beyond pleading guilty. And that's what we want to come back to. The first that he demonstrated was that even though he pleads guilty, he says that he shouldn't be punished for them because he was implementing the instructions that he had been given as a soldier. The prosecution, Your Honor, finds this defense to be baseless because what Bizimana presented as what should be done, or as what should be a reason for him not to be punished for the crimes committed, we find that when we follow the laws and what the law provides, if he pleads guilty for what he committed, basing on Article 46, Paragraph 2, Law 68/2018 of the 30th August 2018, as provided by the law and the punishments, we find that in this article, it is provided how he shouldn't be punished or what removes punishment in paragraph 2. It states that punishment is removed when someone implements instructions given by a legal representative or legal law. Your Honor, the prosecution, basing on this article, finds that Bizimana Kassien, giving his reasons that all the crimes he committed, that he shouldn't be punished for them because he was implementing instructions given as a fighter, as a soldier, we find that this shouldn't be reason enough for him to be acquitted, because basing on Article 186, there are 2 things in this article. The first is that the lawmakers have taken time and space to explain who the legal representative is and who implements instructions as given, and what it means that one is acquitted. This leader has to be approved legally. There is nowhere where Bizimana Kassien showed that the instructions he followed as he committed those crimes were instructions given by a leader who is accepted legally. Even though that's how it could have been, he was simply implementing instructions given by his leader, a leader of a terror group of which they are all members, and they all share these crimes of committing terror acts. The second is that we find that it is an exception given in this article. It is stated that even though he follows the instructions given by a legal leader, the one who commits these acts, respectfully, they cannot be acquitted as long as the act they have committed is against the law. Your Honor, we find that on the case of Bizimana Kassien, we should say that this is incomplete for him, because this leadership, or as it was announced, for him to commit these crimes, even though there were instructions given, even though the instructions he was given were against the law, he cannot deny responsibility of committing crimes such as killing people, damaging infrastructure, committing armed robbery as we presented to the court, and then say that he's not liable, because we have presented that his leader was not legally accepted by the law, and even the acts that they committed were acts that were against the law. So in both ways, as the law provides in this article, there is nothing that Bizimana Kassien has presented to the court, since he pleads guilty to all the accusations, all the crimes committed. The instructions he had been given as a soldier, all of that, there is nowhere where it is said in Article 76, but according to this article, it is provided why all the crimes, why he would be acquitted. We find that what Bizimana Kassien is saying is baseless. He has to be sentenced for the crimes committed. Your Honor, as provided by the article in this law, and connecting it with what Bizimana Kassien himself said, we find that it was explained by different writers who came back to acquittal, the acts committed and the acquittal that they would be given depending on the leader who has given the instructions to them. This goes to emphasize what the prosecution had just said, because we find that the one who committed these crimes, even though they were following orders, the orders they were following were against the law, and since they were against the law, the acts they committed, they should be punished for them. And we find, we'll find at least two experts. There is Christiane Renaud and her colleagues. They wrote the book Droit pénal régional, or regional penal law, and they talk about what happens when one implements or follows instructions given by a leader, and this is how they explain it. They were basing on the Belgian Penal Code, and they say
le 260 du Code pénal qui implique la...
They say that the legal excuse under the penal code will not be accepted if the person acted in full consciousness under orders. If the orders are illegal and he cannot be assumed or supposed to not to know that it is illegal, then he's liable. And this is on Article 125 and also 260 of the Penal Code. It says that you cannot be excused of liability or freed of liability simply by saying that you obeyed orders and you did not know that these orders were illegal. Because even if you know that these illegal activities are illegal, you know that they are illegal, that the orders are against the law, therefore you are liable. So this answers the question, how can a person know that the orders are against the law? How they know that the orders given by their superiors are illegal or unlawful? Well, there are cases, obvious cases, where it's obvious that it is certain that he knew. In this case, Bizimana, we have already indicated what he did, especially when he was cooperating with the Rusizi group, where armed groups attacked, guns and other ammunition were crossing the border, coming from various areas, and these people will come and throw grenades in public places where they will attack public transport vehicles and crowded places. Therefore, even apart from Bizimana, no other human being would look at that and think it's not illegal. It is not possible that Bizimana did not know or could not know that these were illegal acts. And he cannot hide behind instructions or orders as a fighter. So this, Your Honor, is what we were saying. We've been saying the authors and experts that we have just cited have shown clearly that the type or the character of the act itself speaks to its illegality or otherwise. There is also another book by Hara Renou, Droit pénal général. And this author was addressing the French Penal Code, and he said that he was writing about a person acting under orders by a superior. He says an order is only legal if it's given by a legitimate entity, person or entity, that is a public, administrative, judiciary, or military authority. But if the order is manifestly illegal, the person receiving the order will have to refuse the order. If he acts under this order, he is penally responsible. He's liable to punishment. It's obvious, therefore, that as regards Article 124 of the French law, a person who obeys orders and implements the order but is obeying the order of an illegitimate authority, then he is liable. For example, you have a leader or a superior or a commanding officer, and if that authority is legal, or legitimate, but gives an illegal order, the person is not liable to obeying it, or is not obliged to obey. Especially if it is very clear that it's an illegal order. Also, you cannot be punished for disobeying authority if you disobeyed an illegal order. On the contrary, it is the implementation of that order or the following of that order. When the order is obviously illegal, it is that which makes you liable to punishment, because you are responsible for that act, and you cannot hide behind it was an order screen. So this is what we're saying. This is how we began. We began by citing Article 60, paragraph 2, where we say that orders are obeyed only when they are legal. Biziman's case, it is clear that what he did was obviously illegal, and therefore he cannot be excused, because if he obeyed an order that is obviously illegal, then he's liable. There is no obligation to obey such an order. In fact, you cannot be charged with disobeying orders, but it is when you accept that to implement that order that you are liable to criminal punishment. Therefore, sir, Bizimana Kassian has accepted responsibility for those activities, but he said he was obeying orders. He said he was obeying commanding officer, first of all, and we said he was not a legitimate commanding officer for a soldier. Second, what he was ordered to do was clearly and obviously illegal, and therefore he cannot be cleared of that. He has to be held responsible because his liability cannot be lifted. Second, Bizimana Kassian said, as already mentioned, that he accepts responsibility for all his acts. But he mentioned the Lusaka ceasefire agreement of 2099, July, where the government of Rwanda and the government of the DRC, Democratic Republic of Congo, on the 17th of the same month, and also a communique by the ministry in September 2002. And all these concerns the repatriated forces, formerly illegal forces that were repatriated. Therefore, we should be considered as a repatriated element, just like those from Mutobo were so considered and accepted back into the country freely. But he's not right. Neither the Lusaka agreement nor the minister's decree that he refers to are applicable, because none of these texts remove the responsibility of the judiciary to try Bizimana Kassian or others for the crimes that they are accused of. Looking specifically at the arguments that they brought forward based on these various juridical instruments, we find that he has no basis to claim that he is not liable to criminal prosecution. For example, in Article 1, paragraph 22 of the Lusaka Agreement, which is what he cited, there is nothing in the Lusaka document that shows that Bizimana Kassian should not be tried but should be released as a repatriated armed group member. As we said above, all countries that implemented or rather signed the Lusaka Agreement, it is said that they should have a system for disarming the group, including the genocide process.
Of locating, identifying, disarming, and assembling all members of armed groups in the DRC. Countries of origin of members of the armed groups commit themselves to taking all the necessary measures to facilitate the repatriation. Such measures may include the guaranteeing of amnesty in countries where such a measure has been deemed beneficial. It shall, however, not apply in the case of suspect of the crime of genocide. The parties assume full responsibility of ensuring that armed groups operating alongside the troops or on the territory under their control comply with the process leading to the dismantling of those groups in particular.
What we find, Your Honor, in this paragraph 22, which is what Kassian used by claiming that he should be taken to Motobo and demobilized and repatriated. The signatories also committed to disarming the groups before the groups from which these people came from, but the genocidal forces, it was said, would be tried. And therefore, the disarmed group should be disarmed, identified, and kept together in the same place for purposes of further verification. And the countries of origin of these people, or the members of these armed groups, committed to taking all measures to facilitate repatriation of these former armed groups. And these people should be pardoned so long as it is proven that pardon is a more profitable measure compared to all those who could be taken. However, it was said, if the crime of genocide is involved, no such pardon will be accorded. And the text says further that the signatories should be should ensure that the armed groups that were operating on their territory should be rounded up and dealt with according to the provisions of this agreement of Lusaka. So this is what he says in Article 27 of the Lusaka Agreement. Former fighters in Congo, DRC Congo, take all measures to repatriate their members
may include ntabwo ari itegeko.
But it doesn't mean that they have to. They have to accord pardon. They may pardon the people if they see that it is expedient or more profitable. So it is not an obligation, and in fact it doesn't mean that it's a general measure to be taken. It's not recommended as a general measure. But if the country finds that this is more profitable for the country, then pardon will be awarded. Therefore, that is not an argument. This article is not an argument for Cassian to claim that he deserves to be pardoned, because, he's saying that he should be taken treated like a repatriated and pardoned former combatant. It's not a law. It's not even an obligation. He just recommends that countries may demobilize and pardon and give amnesty to such fighters if the country deems it the more useful for its purpose. Okay, so there is no obligation to pardon. So I think you are reading too much through this article, therefore that is not acceptable. Further, amnesty or pardon is a specific case. There is no law that accords general amnesty to people like him and his co-accused and other co-fighters. Therefore, he cannot base his argument on this article or this text in general, this agreement of Lusaka, to say that he shouldn't be tried. Another point that he made, he invoked the Lusaka Accord and the Nairobi Statement. Just a moment, before you go to those two instruments, I think you have already explained this sufficiently. But he said that there were people in the same situation who are not here before the court, but who still in that Mutobo center. That's what he meant. He said there are people like me who are in Mutobo. Why not me? Exactly. Why did you bring me here when my colleagues who are in the same situation, the same problems, were taken to Mutobo? So, okay, of course, apart from the documents that he cited and so on, do answer that objection, please. Thank you, Your Honor. I think we are about to come to that point with your permission. We wanted to say that before he cited this document, he has not brought names or specific identity of anybody whom he says is among the demobilized or repatriated in Mutobo. Therefore, that argument could not be pursued, because in any case, each accused, of course, can bring witnesses, but there are rules to witness action. So he may have claimed that there were such people who are in Mutobo, but we have no knowledge of that. The court has no knowledge of that. Second, Your Honor, even assuming that there are such people in the Mutobo Center, well, there is a law. The prosecution is invoking. There are there are what we call opportunity of investigation and accusation. We have had no opportunity to pursue the case of these people. He has given no cause for us to go after these people, as it were, because this is just abstract. We don't know who these people are, what do they do, where are they exactly, and why does he think they are in the same case as he is? So I think these are the rights of the prosecution. Is a prosecution that determines who is to be pursued. And we have not pursued this case that is mentioned to Bizimana. First of all, we don't know whether these people really exist. We don't know where they are. There was no case against them. But in any case, this is the prerogative of the prosecution to prosecute whomever they see fit. Now, what about, yes, I understand that, says the president. Yes, you're right, but maybe there is a need to investigate that further, because maybe you may find that those who were giving him orders have now turned out to be legitimate superiors. Do you understand the point? I think so, sir. Well, I think the fact that a time came when countries put their head together to find solution to armed conflicts and then forgiveness was accorded, or amnesty. Being amnestied does not, whether under Lusaka or Nairobi, does not give you a right to be legitimized. So the objective was to improve the security in Rwanda and Congo and the region in general. Therefore, the fact that these countries sat together, came to some agreement, and made some commitments for the purpose of serving our security by disarming these people, demobilizing them, cannot lead us to deduce automatically that these people have now become legitimate. Because had they been legitimized, we wouldn't be here pursuing and suing armed groups, illegal armed group. In fact, it is precisely the opposite. Because they are illegal groups and illegitimate groups, this is what prompted the countries to get together so that they can eliminate this problem. And in fact, it's the security of the region that led the leaders to come together and resolve this problem of these illegitimate groups. There is no juridical instrument, no law, no provision of any sort, Your Honor, that has ever legitimized these armed groups, whether amnestied or not. Second, the fact that these people were granted pardon in some cases, they were pardoned not because they had acted well, not because they were forgiven for what they did as such, but precisely because they have committed crimes. You are pardoned if you have committed crimes. And they were pardoned because the insecurity situation had been quite dangerous in the country, in the sub-region. And it was decided, therefore, that it would be best for each country to commit to a certain number of measures and also collaborate with the others in looking for, identifying, and destroying the camps that these people were living in, and dismantle their groups and disarm them, rather, and dismantle their camps, and then take them, repatriate them, whether followed by amnesty or not. What we have now just completed what we wanted to say on the Lusaka Agreement. Now the Nairobi Declaration, Article 9, does not provide for what Bizimana is asking, to be not to be held liable, but to be demobilized and repatriated and reintegrated. This is what he said. Or he is asking to be treated like those who are in those camps. And he says we might like to say that this was a result of an agreement between the two countries, and Article 9 shows that although DRC committed to certain measures, it did not commit to looking after those people who had been taken to Rwanda for trial, those who were members of these groups and committed crimes while in Congo or in Rwanda, because Bizimana is in both lands. But if he committed any crime in Congo, he may be tried under Rwanda, but he is no longer the responsibility of Congo. And also the those repatriated from terrorist organizations or infiltrated forces. If you look at the statement, it explains the laws that govern it, and we can see that it was an implementation, a kind of, we can say it's a decree of the implementation, or a statement on the implementation of Lusaka, Nairobi, and similar agreements. These agreements had annexes. Annex B, for example, Annex B sets forth what needs to be done by each country, what the countries had committed itself to. It was not open-ended. The country committed itself to certain actions within a certain time frame. So this is obvious. These countries got together, had a plan which had a timetable. Say, for example, if the activities to be carried out in Congo, for example, disarming them, what is the time frame? Repatriating them, up to when? To what date? So all these things had a specific timetable, and as you see on Annex B of the Lusaka Agreement, and the others as well, the Annex sets forth the activities and the timetable, and it shows, in fact, that the last activity was given 360 days from the day of signature of those agreements by all parties. Therefore, at that time, Bizimana was already a member of these armed groups when these were signed. If he was really keen on benefiting from these agreements, and he thought they should be implemented, why didn't he comply with them? Why didn't he do what was provided for example, lay down his arms and take the opportunity to be repatriated? Because in fact what he did, he came from FDLR FOCA, moved to CNL there, and then when he joined with the other groups, then he became a member of the armed group of that outfit, FLN. So while he was doing all these transfers and so on, the agreements were being implemented. If he took notice of the fact that the last act of this agreement was given 360 days to be implemented, well, that was plenty of time for him to have moved out of these activities and joined this agreement. 22 years later is only when he's remembering that there were such agreements. That cannot be assumed to be a fact. If he never wanted to be disarmed or to put down his arms, but instead spent all those years in fighting and disturbing the peace, and in fact the insecurity, causing insecurity to both countries, he cannot then come and say that he wants to profit from these or the ministerial decree, which was in fact a means of implementing the agreement. He should have taken advantage of that, and he could have presented himself to the place where the place of collection of fighters, so that he's demobilized and repatriated. So we're saying this because, as we've already said above, Your Honor, the way we interpreted Article 24 of the Lusaka Accord, we think this is very clear from a general point of view. The people were demobilized and repatriated, and then you wake up one day 22 years later and say, oh, by the way, those agreements, I should now benefit from them. That is, Your Honor, that is not at all possible. There is nothing in these agreements that exonerates him or provides that he should be treated like as it is provided for under those rules. For example, while these agreements are being implemented, he should have benefited from that, but now there is no cause for him to invoke those texts, whether these or other laws and other practices. To this end, Your Honor, he is invoking these legal instruments so that he may benefit from them and be taken to Mutobo as a demobilized, repatriated element. They do not apply. And the prosecution has full right to pursue his case, and he himself is liable to the consequences of his acts because he obeyed illegal activities, illegal orders from an illegitimate authority. He has not taken advantage in due time of the Lusaka and other instruments, cannot therefore be repatriated, and we conclude by asking the court to punish him and sentence him according to the charges that have been proven. Therefore, Your Honor, we request your decision on this so that we may begin our reply to the case of the following indicted.
Thank you, Your Honor. Honorable judges, as my colleague has just said, we're going to look at the punishments for Bizimana Cassien. We ask the court to approve the sentencing of this crime, joining an illegal armed group. This crime is punished by 459, paragraph 2 of the law 01/12/OL of the 2nd May 2012. In the laws pertaining to punishment, he should be sentenced to 10 years in prison. Bizimana Cassien should be sentenced for being in a terror group, a crime punished by Article 18 of Law 46/2018, the law pertaining to fighting terrorism, that he should be punished with 20 years imprisonment. Bizimana Cassien should also be punished for rebellion and motivating others to join a terror group. This is punishable by Article 20 of Law 46/2018, a law against terrorism, and he should be punished with 25 years imprisonment. Bizimana Cassien to be sentenced for using explosives in a public space against the law. This is punished by Article 24 of the law 46/2018 in the law against terrorism. And for this, he should be punished with 25 years imprisonment. He should also be punished for the crime of killing people and committing acts of terrorism. This crime is punished by Article number 2 of the law against terrorism, and that he should receive a sentence of 20 years imprisonment.
ahamwa n'icyaha cy'ubwinjiracyaha bw'ubwicanyi nk'igikorwa,
that he should be punished for killing as an act of terror, and this is punished by Article 19 against in the law against terrorism. And for this, he should receive a sentence of 20 years imprisonment. Bizimana Cassien to also be punished for committing arson of property, arson of vehicles as acts of terrorism, and this is punished by Article 112 of Law 46/2018, the law against terrorism, and for this he should receive a sentence of 20 years imprisonment. Basing on the explanations that he gave to the court, he says that he shouldn't be punished. So in his plea, it was incomplete. Yet the crimes he committed were crimes of intent. Based on Article 61, paragraph 3, part A and B of the law 68/2018, the law of punishments, this happens when a crime is composed of many criminal acts, which are also crimes, and these are all crimes with the intent or the focus of one crime. When you look at the acts committed by Bizimana Cassien, you find that they were all of one crime, which is the crime of intent, based on Article 62, paragraph 2 of the law. He is going to receive a sentence, maximum sentence, for the gravest crime, which is 25 years imprisonment. Those were the punishments requested by the prosecution for Bizimana Kasia. If you may, we can carry on to the next. Yes, we can carry on. Thank you, Your Honor. The one who is next. The next person is Rutakamba Jean Bekimas. He is one of the group members of Rusizi, as we read. As my colleague just read, Rutakamba Jean Bekimas was accused of 4 crimes by the prosecution, and in those 4 crimes, 3 of them, it seems he pleaded for the 3, but 1 he didn't plead guilty. The first crime
sino gushishikariza abandi kora iterabwoba.
The first crime was the crime of plotting. When you look at his defense, Batakamba says that he pleads guilty to that, and he also asks for pardon for that specific crime. He accepts the acts that were committed, as he encouraged Biramira and Byukusenge. He also accepts plotting with Bugingo Justin and Bizimana Kasia. But in explaining himself, he says that he didn't have intent to commit that crime. He didn't have a plan to commit that crime. He was just led into that crime by Bugingo Justin. When you look at the explanations that he gave, he wants to prove that the acts to plot and motivate others, he accepts them, but there was no intention. He doesn't accept to having had intention. We, as the prosecution, find that defense baseless. When you look at the written statement that he made, the second written statement, you will find that he accepted that he plotted with Miramira and Byukusenge to commit terror acts. When you look at the written statement and what he said in that statement, you'll find that it's contradictory to what he said before the investigators and even before the court this year. It's very different. He contradicts himself. He doesn't accept his role and his responsibility in committing that crime. He also doesn't show how he was pressured into committing those crimes either. He talks about Justin and Cassien leading him to commit this crime, but he doesn't show any specific pressure that he was put under. But he didn't show how they influenced him to do that. So what we can say, based on the explanations he gave, he says he went to Congo, going to meet Bugingo and Cassien. He says he went so many times to meet them, as the people I've just mentioned. But when he plotted with these people, Bizimana and Bugingo, later on in this plan, as they had asked him to commit these acts of terrorism, he didn't stop them. He carried on committing these terror acts. He went to instigate Miramira and Byukusenge to also commit terror acts. But besides that, Your Honor, he accepted on his own volition to take a gun, to take bullets, grenades, and kept them in his house, in his land, his plot of land. He explained this. And he says that even his land, he rented it $500. What we can say is, having carried on these terror acts, no one, Your Honor, no one did he inform, no leader, official leader, legal leader, did he inform that he wanted to live this life. He never presented any wish to stop committing these acts. For him to say that I was pushed or pressured by Bugingo and Justin to commit this crime, but I approached such and such a local leader, but he chose to keep these military weapons to later use them in terror acts. So, Your Honor, it's clear that he has responsibility here in this crime. He is liable. He can't use the excuse of Bizimana and Bugingo. Another thing, Your Honor, is that Matakamba Jean Berkimas was someone very crucial in the acts committed in Rusizi. There are so many crimes he committed. And Your Honor, some of the people that he instigated, such as Byukusenge and Nibiramira, there are some of those who committed those crimes in Rusizi. So we find that it is evident that even though in his defense he demonstrated this, he didn't show any specific will to stop committing this crime. So his defense is baseless, as he explains. If there is no other concern, we can carry on. For the second crime, Your Honor, the crime of killing people as an act of terrorism, in his defense for this crime, we are not saying that he personally committed it, but him as Matakamba, as he pleads guilty, he says he didn't receive specific instructions to go and kill. And he says that people gave him guns and bullets, but they never gave him instructions to go and kill. But the prosecution finds that his defense, the defense of Matakamba, shouldn't be considered. Because based on the defense of Bugingo Justin, he kept these weapons in his house. And he actually gave the weapons to other people. We explained it also in detail. And even these weapons, the guns, the bullets, the grenades, they were used in different attacks in Rusizi. Your Honor, if we look at his defense, what he explained in his written statement of 24th September 2020, where he expressed that in the attacks that he took part in, there was an attack at a place called Nyakarezo at the bus stop. He says that we shot a lorry and we broke the windshield and the driver came out, but he wasn't wounded. These are the words of Matakamba himself when he was facing the prosecution. He therefore accepts that in this attack with his colleagues, the soldiers, the fighters who were fighting, they shot at a lorry and broke the windshield. To break the windshield, as you know, this windshield was in front, so the target was the driver. But the driver survived. But in his written statement, there is a place he says that even when he accepted it, he says that after shooting at this driver, he took cover under the lorry and he went and phoned the driver and went to apologize to him. That's what he said. But, Your Honor, that's subversion, really. Because he wants to show that he wasn't responsible for what happened in that attack. But as we see, this lorry that was shot at, the driver could have died. He just survived miraculously. So, Your Honor, Matakamba is the one who also gave the grenade. The grenade that was set off in Kamembe in Rusizi. We also explained that it's near a bar called Stella. And this grenade was set off in a public space and people were wounded. So people having not died doesn't mean it was his own will. People survived miraculously, Your Honor. Though he didn't personally throw the grenade, but he accepts having given the grenade. And it was set off by someone called Byokusenge. So Your Honor, the plan was to kill civilians. And Matakamba with his colleagues, they had, as the prosecution showed, and also through different documents, even the indictments, paragraph 584, Your Honor and honorable judges, as we have said it, the crime that we're accusing Matakamba, the crime of killing people as a tool of terrorism, Article 21 of the law and the punishments, it states that this crime is punishable by law. Though what was the intended crime wasn't achieved for reasons that the defendant may not have known, but having shot this lorry near the Stella Bar, this was committed somewhere. Since no one died, for reasons that were beyond their control, another thing, Your Honor, it's Article 2, paragraph 4, Part A, a terror act that has been planned, that is against the law, that can take lives or put people in insecurity and lack the freedom they need, and even cause death of any given person. Your Honor, cause death of any given person, and that's what I want to underline. Matakamba Jambe Kimas, the acts that he pleads guilty for committing them, they were intended to kill people. So, Your Honor, we find that these acts committed that Matakamba pleads guilty to, and he justifies himself by saying that he didn't have the intent, we find that baseless. That's why we ask that he should receive the punishment for this crime, as we expressed it. Your Honor, if we can proceed to the next crime. Thank you, Your Honor. The next crime is the crime of being part of a terror group, which is the third crime that he defended himself on. Matakamba defended himself on this by saying that the terror group MRCDFLN, he is not aware of it. He's not aware of MRCDFLN. He says that even though FLN, that he doesn't know FLN, and it was later that he accepted knowing FLN. So in this crime, he denies it. He denies responsibility, and he says he was never part of this terror group. But in his explanations, Your Honor, we find that Matakamba says that Bizimana Kassia told him about FLN. He told him about FLN and that he works for FLN and that he can help him in the works of FLN in Rusizi. In his explanations, Your Honor, he says that what he was responsible for was to help Bizimana Kassia and to assist FLN, but he doesn't know FLN, MRCD FLN. The first thing that we can point out, Your Honor, is that that defense is baseless because based on Article 18, that is Article 18 of the law against terrorism. Your Honor, we say that a person who accepts and who is in a terror group, who is part of a terror group, or who does anything that empowers another terror group commits a crime. Your Honor, when you look at the defense of Matakamba, there are different acts that he himself pleaded guilty to. And there are attacks that he actually played a role, an active role in, such as the attack by the bus stop. All these different attacks that he took responsibility for, using weapons, guns, grenades. And he says he kept these military weapons himself. When he says that, he also says that he's the person who gave the grenade that was used in Kamembe. We find that to be an active role that he played in this terror group, as it states in Article 18. So, Your Honor, in this article, this article doesn't provide that you have to particularly know this terror group. The simple fact that you have played any given role, any supportive role in terror acts, you are guilty. So we find that Matakamba, his defense, when he said that he wasn't aware of MRCD FLN, we find that to be baseless with regards to this crime. Basing on his defense, therefore, in the court and in his written statements, we find that he contradicts himself as he said it in his statements, in his submissions. He says that he accepts a crime, and then when it's in the court, he gets in court and denies the crime. So we find that contradiction to be doubtful. If you may, we can go to the fourth crime. The fourth crime, Your Honor, which is the last crime for Batakamba, it is the crime of using explosives in a public space against the law. Again, for this crime, Matakamba says that he pleaded guilty for this. He kept guns and bullets, and he also accepts distributing these weapons. But in his written statements, in his final submission, he denies the crime. And he says that the attack in Kamembe, he didn't take part in it. And he says that he gave Nsabimana and Damascene a grenade that was used in Kamembe. But in his defense, he says that he was never part of that attack. So we find that, Your Honor, what he says in his written statements and in his defense in the court, we find it to be contradictory. And due to this, we say that what his statements are should be doubtful. There is nothing much more to say about Matakamba, but we can proceed with the punishments for Matakamba. The sentencing.
Urakoze cyane nyakubahwa Perezida. Nyakubahwa Perezida rero.
So, Your Honor, may we continue as regard with Jean-Pierre Kimanzi, so that he is sentenced with his co-accused of terrorism, which is punishable by, as provided for by Article 46 on terrorism, and it's provided that he should be sentenced to 25 years imprisonment, and assassination and killings for purposes of terrorism are punishable under Articles 49 and others, and of the article against terrorism, punished with 25 years of prison. As regards being part of a terrorist organization, the relevant article provides for a term of prison of 20 years. As regards the illegal use of explosives in public space, public places, Article 24 of the Law 46-18 of the Law Against Terrorism, imprisonment of 25 years. Based on the explanations given by the prosecution, Matakamba Jean-Pierre Kimanzi has accepted the charges, but he said that he did not commit them willingly. He was hoodwinked and cheated by his colleagues, including Jean-Pierre Kimanzi. Therefore, he had no criminal intent, but in fact he did have criminal intent, and therefore there can be no reduction of pain. Following article paragraph 1 and 2 of Article 69 or 68, Article 68, it says, which provides that one act of one crime that includes a series of other different crimes should be punished in the same way. Therefore, Your Honor, since in fact a number of charges but that come under the same crime with the same intent, we therefore propose that, as provided for by Article 62, paragraph 2, that he be given the highest sentence, life, or rather imprisonment for 25 years. This is the highest for this category of crime. So with your permission, shall we move to Shaban Emmanuel? Thank you, Your Honor. Thank you, Your Honor. As thank you, members of the bench. We shall now proceed with Shaban Emmanuel and begin with his defense. Shaban Emmanuel, in written submission, but also during his appearances before the court, he admitted and accepted all the charges brought against him, but when he was pleading in this year, he did not accept that he is the one who recruited his younger brother, Nikurwe Simeon. He said he met Nikurwe Simeon through Bugingo, because Bugingo had told somebody who was looking after his farms, to whom he said that he wanted somebody to run an errand for him. Therefore, we found that this defense on the part of Shaban was unfounded, because Emmanuel Shaban did, in fact, put the two men in contact, Nikuzwe and his brother, knowing very well that Nikuze was going to go to join an armed hooligan group, because he had, in fact, already recruited him. So this is what said. This is what he said. This is what was said in his statement under question 2 of the questioning, the questionnaire. He also said that he mobilized Nikuze Simeo to join his friend in a terrorist group. He said the following: I asked RUSESABAGINA and Pasi when we were in Bukavu. They said, well, we want to extend our area of operation. We want to leave Mpururu and we expand in the direction of Bugarama. I asked my brother Nikuze Simeo in Rusizi, Rwimbogo village. I said, join me in Bukavu. And he came, and I said, go and help Pasi in his activities to disturb the peace in the country. He didn't say anything. So later on, I put him in the hands of Ujingo. I asked Ujingo to take him in charge, take charge of him, and this is how he eventually joined. And this is Shaban himself who made this testimony, which shows that Shaban recruited his brother Simeon Nikuzwe and sent him to Bujengo to be taken in hand and work under a terrorist organization. And Shaban knew very well that this was the case, because what he said in the court is different from what he said in his questioning. Now, what he said to the prosecution, in fact, agrees with his appearance in court the first time when, during the period of his temporary detention. And the report is clear about that. He made a statement. And in fact, it accords also with what the Gasabo court in 2020 provided for when it decided that Shaban and his co-accused should be detained or imprisoned. Now, also, when he was being questioned by the prosecution, again last year, on page 2 of his statement, he was asked whether what he said during the investigation and also during his first court appearance regarding his imprisonment, he was asked whether he had anything to add or change. He said, no, I can't add anything or subtract anything because I told the whole truth. If he said he gave the whole truth, either to the prosecution or the first court appearance, and his written statements, that shows that this is the truth, what he affirms himself, and that he mobilized and recruited was sensitized his brother, then mobilized him, recruited him, and sent him to work in a terrorist organization, and therefore we make a submission to the court for their appreciation. Your Honor, members of the bench, the recruitment by Jean-Veric Mans of his brother Simeon appears also in the dossier submitted by his lawyer, page 3, last paragraph, where it says, it reads, after receiving the money, Bugingo came and asked him whether he can think of somebody he can also recruit. So before taking the money, he was asked that, and then he thought of his brother, and he recruited his brother and sent him to this group because of the money they were giving him. So he put his brother's life in danger for money. It is clear that in other instances as well, he's the one who arranged for his brother to meet Bugingo. It is all, he admitted it, and it's even in his written statement and his lawyer's statement as well, so that he knew very well what he was doing. He connected his brother with Bugingo, knowing very well what Bugingo was involved in, that is act of terrorism. Therefore, we should also add at the time that when Nikuzwe met Bugingo or was sent to Bugingo, Shaban mobilized him, knowing very well that he was drawing him into a terrorist organization. In February, or rather in May this year, Shaban demonstrated the act of terrorism that he committed. In fact, he said that he began in 2019. When he began working with Bugingo, it was a boat that was in which these armed groups were crossing across to join Nyungwe Forest. And he knew that these were FLN fighters, that was because the person who was steering the boat told him that they were fighters. In 2019, he began to accompany Passy or Bizimana Cassien. And in 2019, September 2019, he was then able to hand over his brother to this terrorist group. This is another proof that Shaban Emmanuel encouraged his brother to join what he knew very well was a terrorist organization, especially as he himself had been working with the Passy and Bugingo in various terror activities, and he knew very well that this was what this organization was doing. In his defense, Shaban claimed that he didn't know what Bugingo wanted to do with his brother or what job he wanted to give him. That is not a fact, and we hope that the court will appreciate that this is not true. This is what we had to say, Your Honor, in response to his pleading, and with your permission, if you have no objection, we shall now move to our request for sentencing. As regards Shaban Emmanuel, the prosecution requests that the court confirms that Shaban Emmanuel is responsible for terrorism and plotting against the country as provided for in the relevant law of 2018 against terrorism. Term of prison, 25 years. That Emmanuel Shaban used explosives in public and crowded places, crime punishable under the law of 2018 against terrorism, and that the sentence or the appropriate punishment is 25 years imprisonment. That he was a member of a terrorist organization as provided for by a law of the law of 2018 against terrorism. Punishment, 25 years imprisonment. That he was a member of a terrorist organization as provided for by paragraph 2 and 19 of the 2018 law against terrorism. Should therefore be imprisoned for 20 years. That he committed arson and burnt down public transport vehicles with intent to terrorize the people, as provided for in the relevant article of the law of 2018 against terrorism, be punished by a 20-year prison term. Your Honor, we request that you look at the arguments presented by the prosecution, whereby Shaban Emmanuel has accepted the charges brought against him, but he said that his younger brother, Nikuze Simeon, he encouraged him to go and join this group without knowing. He says that it was not, without knowing that it was a terrorist organization. But however, since he intentionally committed these crimes and actually did admit to committing them, we request the court that given this additional factor, his sentencing should be not reduced. Pursuant to the law 68 of bar 68 of the law against terrorism, it provides that if a series of charges, but all with the same intent, will be published according to that article, and therefore Shaban has committed a series of crimes for which he was charged separately, but in fact they all have the same intent, which is terrorism. And therefore, Law 68 under the Terrorism Act, we request that he be given 25 years of imprisonment as the highest for this category of crimes, and that there should be no reduction of this sentence. Thank you, Your Honor. Yes, excuse me. I was consulting my colleagues. I don't think we can begin with Nhyiramira because there isn't much time left. But in fact, I think we should spend this time to plan. What time do you plan to complete your pleading? Because we have reached number 8. Sankara was, we had a lot more to say compared to others. Do you think tomorrow will be sufficient for you to complete your work? I'm saying that because we have to plan ahead so that we know how to organize ourselves. Do we complete our work this month, or do we maybe take also next month? This is what I want you to understand. You understand that we have not yet done or announced our plan, but what you think? Yes, sir. I think tomorrow we can complete what we have to say, because it isn't much. We want to respond to the defense of the people remaining. There are several, but I think their cases will not require a long time for our reply. Well, maybe we won't have too many questions then, says the President. Yes, Your Honor, I think we will not have too many questions, because the questions that might have cropped up have already been asked, because the points of law are the same, the background legislation and justifications are the same and have already been covered. Very well, let's see if we can complete our work tomorrow so that we can move to another stage. So I recommend that we stop here and we resume tomorrow at 8:30 as usual. Please, registrars, complete your paperwork so that we can sign them and then leave the room.
Nsabimana Kariste azasinye na Maître Nkundabarashe Moise, Nsengimana Herimani na Maître Rugeyo Jean. yazamutse cyane akarisiti hari abantu bamukwebye.
abaregera indishyi nabo bakwigira hano bakasinya. Maître Nditiye Yusuf, Nsengiyumva Vincent, Nkundizera Bertin, Hakizimana Tatien,
Matakamba Jean Berkimasi,
Maître Mukashema Marie Louise, Maître
muze muhana intera, hari igihe muza mwegeranyaho cyane, muze muhana intera ngira ngo hari igihe mwegerana cyane.
Shabani Manuel, Nsabimana Jean Damascene.
Maître Mukashema Marie Louise,
Shimimana Emmanuel, Niyirora Marcel, Iyamuremye Emmanuel. Bizimana Cassien, Nizeyimana Marc. Ndagijimana Kwitonda, Hakizimana Theogene na Maître Mugabo Yusuf. Byukusenge Jean Claude, Nikuzwe Simeo, Ntabanganyimana Joseph na Ntibiramira Innocent. Ntibiramira Innocent. Suwa Ntibiramira Innocent kutahari kutaje. Yasinye kure.
ko mbona hari abantu bari kuzamura basaba ijambo kandi
I see there are people asking for the floor, but we are about to conclude. Can you not speak tomorrow? Or you want to sign? Very well.
yaba ari byo rwose mba mutasinye babasinyishe.
Very well. You may sign. Step forward, please. Come along.
urukiko rushoje iburanisha ry'uyu munsi.
We have concluded the work for today. The court will be in recess. Please rise.